topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Experts show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon. Welcome to another Ask the Expert show where we bring you the top experts in the field of legal, health, financial, and home improvement. We have got, this is the first Thursday of the month, so that means K. Bender Rimbaum. They are a community association law firm. Please, if you have a question, please call us at 561-623-9429. Our chat line is not working today, so we will not be able to take any kind of chat questions, but we've also got a ton of questions for our great guest, attorney Robert Kay. Good afternoon, attorney.
Hello, Steve. Hello, everybody. Happy Thursday.
Happy Thursday. Listen, we do a live show. Most shows on are pre-recorded, just so that if there's any technical problems, they don't have a problem with it. But we do a live show, and we are having a slight bit of technical problems, but we are here. We're going to have a wonderful show today. Robert, tell people about K. Bender Rimbaum.
Well, K. Bender Rimbaum is a law firm that primarily specializes in the area of community association representation. We do that out of our offices in Pompano Beach, Palm Beach Gardens, Orlando, and Tampa. We also have a meeting facility in Miami if the need arises, by appointment only. We provide all of the legal needs services for community associations, be it dealing with reviewing and interpreting covenants, opinions of authority or responsibilities and liabilities under the governing documents, collection of unpaid assessments, covenant enforcement, contract negotiation with third-party contractors, dealing with cities, permit issues, code violations, dealing with construction defect issues, any aspect of the day-to-day legal need that a community association may have are things that we deal with every day. We have about 20 attorneys in our 4 offices. About half of them are board certified, either in community association or in construction defect litigation. We bring decades, if not into 100 years of combined legal services in this area of the law. And our aim is to provide cost-effective, efficient, understandable legal opinions to our clients in a very timely manner, as well as addressing all of their needs in as aggressive of a manner as the board so chooses.
Robert, you're the senior partner of K. Bender Rimbaum. I think your customer service is like no other. Just kind of touch on that before we get started with the questions, how important customer service is to your firm.
The firm is built on customer service. It's always been our policy to be responsive to our clients, either telephone or more recently emails, on the same day that we receive it. Substantive responses don't take days and weeks to receive. If there's a request for opinion, we strive to put things in a format that's readily understandable to the layperson, that you don't need an attorney on staff to translate the opinions you get from us. and we have live telephone answering, real people.
Yeah, that is so important. I go into a lot of law offices, and many times there's no one there at the front desk even. Sometimes you got to ring a bell. But when we come into K. Bender Rimbaum, there's always 2 or 3 customer service people there to greet you. Customer service is very important. And so is education. You all, and we're going to be talking about the classes that you offer, so many free classes and shows like this, that education is so important to your firm.
Absolutely. In the days since COVID, the Zoom mechanism of providing education services has given us the ability to reach a lot more people than we used to do in our in-person demonstrations that we used to do. We do some in-person things from time to time, but the Zoom format seems to be what most people are most interested in. I think it works for the people that are getting the education as much as it does for those of us giving. We lack a little bit of the personal touch, shaking hands, seeing each other in person, but I think we have a wider reach this way. We do have a number of things coming up in the month of May that we've got going on. Although as this time of year comes along, it tends to wind down a little bit in the amount of programs that we are presenting. But I think there's a good number out there. We're still waiting on the new legislation to reach the governor's desk and see if he's going to sign it into law or not. So there's a lot going on in condominiums. There's a lot going on in homeowners association law, depending on whether or not the governor puts his signature on those. I expect that he probably will, but all of these things go into effect after July, so there is still time for him to do what he's got to do.
And I'm sure you'll have new classes for that as well. Robert, we get so many letters for your show, people talking about how rates have gone up. I don't think people really understand that these rate increases, that the association is also getting the increases. It's not the association's fault. Can you just touch a little bit on that also?
Well, sure. When you say rates are going up, you mean their assessments for their monthly or quarterly or annual charges for operating their communities. And sure, I mean, rates are going up across the board for all of the services that associations tend to need. And they don't really have a choice but to pass those costs along to the individual owners. The only way the association can function is through the assessment process and making sure they budget in a proper fashion so that they have enough money to meet the needs that's going to be coming up during the fiscal year. So that's an important consideration for all associations. Yes. And in condominiums, they have the added problem of the new requirements for structural integrity and additional reserve requirements and significant repairs on many of them that they might have been in prior times kicking the can down the road. But now with the legislation in the next couple of years, there's going to be a lot of work that's going to cost a lot of unanticipated amounts in a lot of condominiums. So that's something that many people are concerned about.
Well, I'm glad how you explained that. We're going to go to get so many letters from listeners and viewers. We're going to start off with John in Boca Raton. Our condo association pays a management company $28,000 a year, and we pay the past president $35,000 a year as a liaison. We have 75 condos in our association. Is this legal? I guess they mean about the $35,000 a year to a liaison?
Well, I think the concern sounds like it's because he used to be the president, and it's possible that this all came about during the time the individual was president, and then whether that's legal. The fact that he or she is no longer on the board and is a hired employee of the association would certainly make any legal concern very minimal, depending on how it all came about and what's the involvement of the board. With 75 condominiums, it's hard to know how many units that is, but I imagine it's a significant number. So while the 28,000 and 35,000 sounds like a lot, it may be a very small portion of the overall budget of the association, but we don't really know from the question. A lot of facts need to be determined in order to say categorically whether or not there's a legal issue. But if the board is aware of the situation, which I assume they are, and there's a formal contract in place and everything was done appropriately at a board meeting and in the open, and it was done before afterward there was any involvement on the board, there shouldn't be a significant legal issue in that particular transaction. Now, whether or not it makes business sense for the association, that's another question. But that's more for the board of directors to answer than the attorney.
Okay. We're going to go to Mary in Delray. This is a condo about material alterations. Her question has to do with material alterations. According to a 718 statute, it requires a 75% vote of total voting interest to approve a material alteration, unless stated otherwise in the documents. Does a difference in voting percentages have to be placed on the declaration, or can it be placed on the bylaws? Our bylaws state that once a quorum of 50% is met, decisions can be made by a majority of total voting interest present. Does this qualify to approve a material alteration?
Well, material alterations and substantial improvements are something that's specific to condominiums, because there is an express provision in 718 in section 113, 718.113, that says there can be no material alteration or substantial improvement to the common elements except as provided in the declaration. If the declaration is silent, then upon a vote of 75% of the total voting interest. So the first thing to do is look to the declaration to see what the voting requirement is for specifically material alterations. It can't be a general voting provision such as what was identified in the bylaws. It has to be specific as to material alterations. If there is no provision in the declaration that talks about it, then you would default to the statute of 75% of the total voting interest. But it is important to carefully review the declaration. Now, it is possible for the association, if it does not have any provision or it's silent on material alteration, to adopt an amendment, which is voted on by the unit owners under whatever percentages the documents provide to amend the declaration, to put in something that is workable for them for material alterations in the future. We see documents that don't say anything. We see documents that give full power to the board to make these decisions, and almost anything in between. Sometimes it's tied to a specific dollar amount for the cost of the material alteration. Sometimes it's a percentage of the overall budget, and things of that nature. So if the association is interested in that issue, it'd be important to get with their association counsel to review the documents and to create the amendment that works best for them.
Okay. This is from Val in Pompano. your backyard. What does the Architecture Review Committee do? We get a lot of questions on ARC, so I picked out one. But they also want to know, are they more powerful than the board?
Well, Architectural Review Committee, I'm going to guess this is an HOA, although they do exist in condominiums as well. But it seems to be more of an HOA issue because there's more potential of exterior changes that owners can make that would require the involvement of such a committee. Their powers and authorities are spelled out in the Declaration of Covenants for the community. They're usually appointed by the board, which means if the board doesn't like what they're doing, they can change who sits in that committee. And whatever authority the documents grant to the committee is the authority that they have. Now, some documents will provide the committee with a decision-making and the promulgation of specifications that are going to be acceptable. Sometimes boards act as both. So it's really going to depend on the situation in the documents and how the community operates. The statute contains a requirement that there be objective standards and guidelines in place, meaning in writing, readily available, and understandable. That can either be by rules or it can be by an amendment into the declaration if no standards are currently there, or sometimes developers do put standards into the documents. So you do need to have something like that in place to be able to take advantage of that particular authority that's put into the documents. And if they're unsure of that situation, it is important to get with association counsel to go over what the documents provide and the best way to reach what the board wants to accomplish.
You know, we were talking about your classes. If you're watching us right now on our TV version, we are running those classes throughout the show right there at the bottom on our scroll. For those who are listening to the podcast or radio, Robert, give everybody your schedule for your classes this month.
Okay. Well, starting on May the 9th at 11:30 a.m. via Zoom, a hot topic, milestone inspections and SIRS, the legal requirements. Alan Schwartz out of our Orlando office will be presenting, and that's hosted by a True Group. On May the 18th at 12 p.m., there's a go-to webinar. It's entitled Condo Assessment Collection. Alan Schwartz side will be among panelists that will be discussing the issue, and it's hosted by the Florida Department of Business and Professional Regulation. This is through the state of Florida, so they're getting into more education presentations, and we're participating with them on some of that. On May the 21st at 11:30 a.m. at Dave & Buster's in Hollywood, there's a lunch and learn, Conflicts of Interest, hosted by Cam Yu, and Michael Bender will be participating in that, Michael of Cape Bender, out of the Pompano office. On May the 23rd at 11:30 a.m. via Zoom, we'll have a panel discussion, again on the topic of milestone inspections and SIRS. Michael Bender will be among the panelists there, and that's hosted by Campbell Property Management. That's May the 23rd, 11:30 a.m. May the 24th at 10 a.m. via Zoom, there will be an HOA board member certification presented by Alan Schwartzide, and there are 2 CEUs available for that for CAMs. And then on May the 29th at 12 p.m. via Zoom, Conflicts of Interest, What You Need to Know, hosted by Trident Management, and Michael Bender will be presenting on that particular broadcast. Now you can see all these on our website, kbrlegal.com. Click on the calendar. You can choose the event you're interested in participating in, get registered for the Zoom credentials, or reserve your spot for the in-person presentations. And I think that's all we've got for this month.
Busy month. Hey, we're going to go to a break. Robert, give everybody the phone number and the website address.
Reach us at 800-974-0680. Write to us at info@kbrlegal.com. Or you can just go to the website, kbrlegal.com. There's a contact box on the first page. Fill out information that's indicated there, and we will be back in touch with you.
Wonderful. We're going to go to break. I'm sorry our chat line is down today, but we will get it fixed. We'll be right back with more Ask the Experts and Kay Bender-Rembaum.
Kay Bender-Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several Kay Bender-Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. Kay Bender-Rembaum is also a well-known provider of free legal education for managers and board members. Contact Kay Bender-Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. This is the first Thursday of the month. That means Kay Bender-Rembaum, Community Association attorneys. We are asking questions that you have sent in during this past month. We've got some great questions, and let's get right to it. Let's go to Kyle in Palm Beach Gardens. If we have money left at the end of the year, can we put it into reserves? I think it should be given back to the owners. What is your thoughts?
Well, it would be helpful to know if it's a condominium or an HOA, but I'm going to go with this as a condominium because that's more a likely condominium question. The statute provides in section 718.116 that if there is money left over at the end of the fiscal year, that's treated as what they call common surplus. And the choices that the board has with common surplus is to use the money to offset future assessments, which is in essence a way to reduce your assessments in the coming year because you have a pool of money that's available to be used for that purpose. And the other is to give the money back. I would say the vast majority of associations choose option A and just roll it into the next budget because if you give it back and then you assess again, it's just back and forth with the same money. If you're able to hold assessments down by using it in the next fiscal budget, members should appreciate that. Putting it into reserves is a trickier question because at least up until the time things change on what you can do with reserves, quite often communities waive reserves or reduce the reserve requirements. So that would limit the ability of the board to just take the money and put it into the reserves. The board can create what they call a reserve or contingency fund and hold it there for purposes of that nature, but that would not be one of the statutorily protected reserves that the board can only use for the purposes that they're stated unless the owners vote to use them otherwise. That's the technical legal answer. The practical answer is if the board were to put it into the reserve account, it's now earmarked there. It can't be used again for another purpose without a vote of the owners. It's unlikely anybody's going to complain about that in a formal fashion to the Division of Condominiums, but it is a possibility. So those are the various options as I see them.
I want to tell everybody we really do appreciate the letters. We know it. You take time to write these questions down. If you can, though, please make sure you let us know if you're a condo or an HOA. It does help a lot. Let's go to Brian in Boynton Beach. My condo will have the first owners meeting this year. Owner has the right to attend such meetings, includes the right to speak at such meetings. Does this apply to renters?
Well, interestingly, in the question itself, he's indicated that owners have a right to speak and renters are not owners. Renters actually don't even have a right to attend the meeting unless the board invites them, which typically, some places do. They open it to everybody there, and some places choose not to. If the board wants to invite somebody who's not otherwise entitled to attend and then allow them to speak, the board has that power. But on the converse of that, a renter doesn't have the entitlement to attend the meeting or to speak at the meeting. It takes an invitation from the board for that to happen.
Okay. We just got a interesting text in. First of all, he's saying how much he enjoys the show. He's considering running for the board. What is entailed? Is it take a lot of time to be a board member?
Well, unfortunately, that's a community by community answer. Some communities, board members attend meetings a few times during the course of the year, and that's all they do. Other times, they're very involved in the day-to-day operation and spend a great deal of time. So it really depends on the situation of the community that you're in. If you're considering doing so, one method of getting a feel for it is to attend meetings and participate as they're going on and engage in conversations with board members and get a feel for what it is they do. Some communities delegate a lot to their property management, so that would mean the board does less. Other communities, they give very little to their management and the board members do it all themselves. But that can change depending on who's sitting on the board. So there is no one stock answer for that particular question.
Does it matter how large the community is on how much work, or is it just still an individual?
Well, certainly the larger community has more issues to address. So I think it's logical to conclude that there will be more that needs to be done. But whether it has to be done by board members or they have various vendors or representatives handling it for them is really what will depend.
Okay. Let's go to Phyllis in Boca Raton. If a board member resigns, does the open seat have to be filled from the members that ran for the board but did not get elected?
No, that's a common misunderstanding that people have. If there's a vacancy on the board, the remaining board members, unless there's something else in their documents, will choose whoever they want, whoever they feel they can work with, to fill that vacancy for the remainder of that term. Sometimes we've had situations where it's right at the annual meeting and somebody gets elected who decided they didn't want to be on the board. So they withdraw and now there's a vacant seat. Even in that setting, it does not have to come from those who ran and did not win. Now, the board could choose from there if they wanted to, but it's not a requirement.
Hey, let's go to Robin in Deerfield. Love your show. I never miss one. I just wish you were on more. You could do that in your spare time.
Sure.
Homeowner who is delinquent. They are trying to sell their condo. Will the title company make the buyer aware of what is owed on the property?
If there is a title company involved, the likelihood is they will do the due diligence that they're supposed to do, contact the association and ask for what's called an estoppel certificate, which has information about the association, which includes any amounts that are outstanding to the association on the account. The statutes do provide other information that needs to be on the estoppels, but the one on this question is the specifics as to the account. And when the association provides that information to the title company, and it's very important that they get that right, because whatever you put on that form is all you're going to get. So if you miss a month in your calculations, that's going to be waived. So you're not going to be able to pursue that. So very important to get the dollar figure on your estoppel certificate correct. Then the title company will typically collect that out of the proceeds at the closing and then send that to the association in relatively short order. If they fail to do any of that, then the association does have enforcement options that they can pursue. And if the title company does not pay the money to the association, the new owner is still responsible.
Okay, let's go to Shelley in Coral Springs. I am a board member. I love your show. All my board members listen to your show. We have townhouses. We have townhouses. So it's condo. Are we responsible for the roof repairs? Our roof is 30 years old. Is a 30-year-old roof insurable?
In all likelihood, the roofs are going to be considered common elements, but this is something, as far as who's responsible, given that you're a townhome community rather than a high-rise, is something that you're going to have to review your documents to confirm. The likelihood is that it will be an association responsibility, but the caveat is it is a possibility that the documents do provide something different. It's unlikely, but possible. As to whether or not the roofs are insurable, that's going to be up to the individual insurance companies. Experience has been that anything over 15 years these days is not something that's easily insured. So if you're approaching 30, then the likelihood becomes less. And if it is insured, then the chances of the cost of the insurance being much greater is another issue. So that's something that's important for the board to get into. It also depends on what the roof is and what condition the roof is and what experts come up with relative to that. 30 years is to the point these days when it's going to be, I think, quite difficult to get a decent insurance contract in place to protect everybody's interests. And since it's a condominium, it's something the association still has to have.
Dan in Hollywood wants to know, we are a condo and the board of directors has decided to build a tent for termites. And they want the owners to leave for 3 days. Several of our owners do not want to leave their unit. What can the board do to get them out?
Well, the board needs to certainly make every effort to persuade them to voluntarily vacate within the time frame that the contract is in place. it's something that needs to be addressed timely, because the termites can be causing damage depending on the type of termites that you have. And I'm assuming, since they're going the tenting method, that that's what the exterminator believes is the most effective method of dealing with it. If the owners refuse to voluntarily vacate, then the association will have to take those owners to court and get an injunction against them, a court order that compels them to vacate during the time frame. And in such event, the court will likely also make those homeowners responsible for the costs the associations incur in going to court, which includes the attorney's fees. So that can be very costly to the unit owner that is somehow fighting the fact that they need to leave during extermination.
Here's Lori in Pompano wants to know, what authority does an HOA board have to tow cars parked on common area street, private road? Do they need to post a 24-hour notice on the car, or just a notice at front of the HOA?
Well, there's a statute that covers the involuntary removal of vehicles from private property. It's, I believe, 715.07 in Florida statutes. And the most common method that's used is, first you have to engage a towing company that's located within a certain distance from the community. Depending on the size of the city that you're in, will determine how far away it has to be. And then there has to be signs posted in the community that the statute identifies the specific language that has to be on the sign, and the towing companies typically will provide that. Where the signs are located will depend on the configuration of the community. If there's limited entrances, then at the entrances and exits is where the signs would need to be. If there's multiple entrances and exits to the community, then the signs would have to be located at various points throughout the community. You know, the signs basically identify who's taken the vehicle and numbers where they can call 24/7 to retrieve the vehicle. These are typically not costs to the association. The towing is charged to the vehicle owner. Any storage costs for the vehicle is also charged to the vehicle owner. The potential exposure to the association is if a car is wrongfully towed, then the owner can get damages if the vehicle's damaged, and attorney's fees. So it's important that the vehicles that are towed are ones that are actually in violation of provisions of the covenants and rules of the association. And that's something that I suggest that the association confer with its attorney to make sure that any vehicle they're targeting does fall within the restrictions. It's important to also note that a new statute that is pending for HOAs has language in it that limits the ability to remove or to enforce against or prohibit certain vehicles. And while there's a constitutionality question about the enforceability of such a change in the statute, because it is a substantive change to what are existing contracts, the declarations of covenants, for those communities that do not have what's called Kaufman language, or language that incorporates automatically changes that happen in legislation, there is the issue of whether or not that's enforceable within that particular community. So that's a very important issue for homeowners associations to get with their attorneys once this new legislation is signed by the governor, to make sure that they're not going to find themselves in a problem when they're removing those types of vehicles.
Lynn in Hollywood, HOA are amending their documents to allow capital contributions. Can condos do the same?
Well, capital contributions has been a confusing issue for a number of people, including the Division of Condominium. Most recently, the Division of Condominium views capital contributions as charges associated with the transfer of real property, which the statute limits to $100. The statute was originally put in place to limit how much you could charge to do background checks, and it tied it to transfers of property. Capital contribution is a method that associations use to have new owners pay a certain amount of money into a fund to offset operating expenses of the association. And while it's tied to the transfer of a property, it's, in our opinion, not what was intended by this particular provision of the statute. But that is the risk that condominium associations face by having that. I can tell you that there are a great many condominiums in Florida that do have those provisions in their documents. Usually they're added by amendment because developers, when they create the condominiums, usually have it for the first purchaser, the one the developer sells to, not every purchase that happens thereafter. So many associations have amended to provide any transfer to have a capital contribution, and usually a couple of months of assessments. It's not generally a large sum of money, but it is an added expense. So whether or not it's enforceable in a condominium is a risky proposition, but until a court decides the issue, it could go either way.
Robert, I wanted to save this till the very end of the show because I'm the one who gets all the letters. People love your firm. Your clients speak so highly of you. It's really a tribute it's really a tribute, though, to your firm. Let's give everybody the phone number and your website again.
We're reachable at 800-974-0680 for all 4 offices. You can write to us at info@kbrlegal.com or go to the website, kbrlegal.com, and there's a contact box on the opening page. There's also information of interest to community associations on there. On the resources tab, there's articles under Rembaum's Association Roundup and Legal Morsels that are topical to things that are of interest to community associations. So certainly we encourage people to look at those. There is no charge for that, and happy to be there for them.
Well, you're with us the first Thursday of each month, and we also do your Tampa show and your Orlando. Robert, we can never thank you enough. The way you present information is like no other. Thanks again. We'll see you again next month. All
right. Thank you. Thank you, Steve.
Thanks, Robert.
Have a good month of May, everybody.
Thank you. That's Hey Bender Rembaum. We get so many compliments on them. That's it for us today. We'll be back again with you next Thursday with more Ask the Experts.
Thanks for tuning in today to the Ask the Experts show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.